Hi, everyone. Good evening. I hope everyone is doing well. I am Immigration Attorney Yael Brudner, and I'm here live on Facebook and on YouTube. Like every Thursday evening, I go live to talk about immigration topics and issues. So today, I am going to answer some of the most frequently asked questions that we get about marriage case or family-based green cards. We often get questions about these subjects, and we get them through our messenger or through email, phone calls, Instagram, TikTok, you name it, the questions come in. So I collected some of the common ones that we get, and some of them from the last couple of days that I think would be interesting for everyone. And if you have a question, feel free to write your question in the comments. Even if you're watching a replay of this, you can also still write a question, and we will try to get back to you as soon as possible. These are questions that, like I said, these are questions that we get often, and the answers to these questions are going to be general answers. So it's really advisable, if you have some of these questions, to consult with an immigration attorney, because believe me, each case is different. Okay, there's almost no two identical cases. So it's always recommended to talk to an immigration attorney if you have a question about your immigration case. Okay, so let's dive straight in to the first question. Okay, so the question is, I entered the US on a visa and I married a US citizen. Can I apply for a green card in the US even if I overstayed my visa? Now, this is a question that we get a lot. People come in on a visa. It could be a tourist visa. It could be a student visa, different kinds of visas. And they, at some point, fall in love, get married to a US citizen or to a green card holder, by the way. And now they want to apply for their green card. And they ask, can they do that? So the answer to this is generally yes. If you entered with a visa, and you can apply to what's called adjust your status in the US. Okay, if you are getting married to a US citizen, which is an immediate relative, your overstay is forgiven. So you can still apply for a green card in the US even if you overstayed your visa. Okay, now if this question is if you get married to a green card holder, that is not so simple. So you cannot adjust status or apply for your green card in the US if you got married to a green card holder. Okay, so if you got married to a green card holder, you have to be maintaining your status. You can't be overstaying your status. Okay, we have solutions for that as well. Once your US citizen green card holder spouse naturalizes, then you could apply for your green card then. Okay, so if that is one solution that is possible in this case. Again, if this is your case, talk to a lawyer. Just make sure that you qualify. Okay, another thing to make sure is that you're not applying too soon after you got married or after you entered. Okay, consult an attorney before you do anything with immigration. Okay, the next question is, I'm a permanent resident. Can I petition for my parents? So that's a question that we get a lot as well. Unfortunately, a permanent resident or a green card holder cannot petition for their parents. So green card holders can petition for two types of people. They can petition for their spouses and they can petition for their children. They cannot petition for their parents. Again, if this is the situation, I would ask the permanent resident, when can you naturalize? When can you become a citizen? Once you are a citizen, you can apply for your parents, because parents are immediate relatives of US citizens, and you can apply for them here in the US, or if they're abroad, there are different options. Okay. The next question is, I entered the US illegally and am now married to a US citizen. Do I need to leave the US to get my green card? Okay. Very, very common scenario. And it's hard to answer this question because there's a lot of different options. There's a lot of different fact patterns that could relate to this question. But let's say someone entered without permission, without authorization, only one time, and then they got married to a U.S. citizen, and they've never left the U.S., only that one illegal entry. So in general, the general rule is that they cannot apply to adjust their status here in the U.S. They have to leave. And they have to do what's called consular processing. So they have to go get their green card or their immigrant visa at the consulate abroad. However, there are cases where someone that's here even can apply for their green card even if they entered illegally. And it's really important to know that there are options. Okay, one option is what's called 245I, which is an option for people that someone petitioned them in the past. So someone petitioned them before April 30th, 2001. Either an employer or a family relative. This could be perhaps someone petitioned their parents and they were included in that petition. If that is the case, then you can your illegal entry would be forgiven through the 245I route. Okay, it's a special form, it's a special application that you apply to, and it allows you to adjust your status here in the US, even if you entered illegally. Okay, and a lot of people don't even know that they have that old petition somewhere. Someone petitioned them a long time ago. Another option to be able to adjust your status and get your green card here in the US without leaving is if you are married to a US citizen or to a green card holder, like in this case, and you are in an unhealthy relationship. You are suffering from abuse, from extreme cruelty. Okay, in that case, you can self-petition. You can apply for yourself. You do not need your spouse to apply for you, and you do not need to leave the country. This is called a VAWA petition or an I-360 petition. You might have heard about this before, and I actually did a presentation about this last week. It's really important to know that you don't need to have physical abuse. You don't need to have suffered physical abuse to qualify for a VAWA self-petition. It's if you're in an unhealthy relationship, if you are suffering from cruelty from your spouse, you can do this. This is something that can definitely allow you to adjust your status in the US, even if you came in illegally. Okay, so if this is something that is relevant to you, definitely 100% consult with an attorney, because there are options. So even if you entered the US illegally, even if it happened when you're very little, contact us. We'd love to help you with this kind of case. We were able to help a lot of people in these situations. Okay. Next question. Again, if you have any questions, feel free to write them in the comments, and I'll try to answer them as we go. The next question is, what's the public charge rule and how does that affect my application to adjust status? Okay, so adjusting status is a fancy word for applying for a green card here in the US, okay? And what's the public charge rule? So the public charge is what's called a ground of inadmissibility. When you are applying for a green card, USCIS or immigration checks a list of different categories to check if you're admissible, if you can get approvable, if you can get a green card. Okay, they check your criminal record, they check your health, they do a medical exam, they check any previous immigration violations. And one of the things that they check is if you are likely to become a public charge. If USCIS determines that you are likely to become a public charge, meaning you are likely to depend on the government for financial help, then they might deny your green card application, okay, if they think that you're not going to be able to provide for yourself financially. And that's why with the green card application, your sponsor also submits financial documents, tax returns and pay stubs and things like that. Now, what's the public charge rule? Basically, what it's referring to now when people say public charge rule, there's a new form that's called Form I-944 that Immigration USCIS added just recently in the last few months that just makes the whole public charge rule rule that was always existing just makes it a lot more difficult. So now they want a lot more evidence from the applicant, for the green card applicant, that this person will not become a public charge. And this form is called the Declaration of Self-Sufficiency. And basically, you're asked to provide evidence to show that you can self-sufficiently provide for yourself. Okay, you're not going to be a burden on the government. And there was a lot of ups and downs with this new form. There was a lot of litigation going around, and actually, there were 2 months that the court ruled that immigration can't demand applicants to use this form or the Declaration of Self-Sufficiency during COVID-19 because it's a huge burden on them. And then another court decided that yes, USCIS can use it. So a lot of ups and downs. Every day the news changes. So it's very, very important, if you are in the middle of a case, if you're thinking about filing a case, talk to an immigration attorney, because it is complicated and the rules change all the time. Okay, even us immigration attorneys, we wake up in the morning and we see new stuff happening. So it's very important to stay up to date and to know the laws, the regulations, and the new policies. Okay. I hope I answered that question about the public charge rule. Okay, the next question I'm going to talk about today is, what documents do I need for a marriage case green card? This is a great question because it's very, very practical. Someone that got married, they want to file their green card case, and now they're asking, so what do you need from me? What kind of documents? So first and foremost, you need to prove that you are married. Okay, you need to prove that you are in a marriage. And how do you prove that you're married? You have to show a marriage certificate. Okay, that's the first thing you need to show. You also need to show all the biographic documents. So passport photo, biographic page, your birth certificates, and things like that. In terms of proving that the marriage is real, okay, that's part of the evidence that you need to submit in a marriage case. You need to show evidence on paper that you guys are a real couple. Okay, so how can you prove you're a real couple on paper? So anything that shows that you commingled, so you're putting your life together. So for example, a joint bank account, okay, where both sides are contributing their pay stubs and their income into that, and they're both taking money out of the bank account, and the bank account is on both names. Another example is a tax return. If you guys have been together for a long time and you've already filed a tax return, make sure you're filing as a married couple, and you can present that as evidence that you showed the government that you guys are married already. You showed the IRS on your tax forms. Other documents is a joint lease, a joint mortgage, car lease, insurance policies, and things like that. And my favorite, of course, is pictures of you and your spouse together. I always say to include pictures with families and friends with you on holidays when you're traveling, and label the pictures so the officer will know exactly who's on the picture and where you guys are at. Okay, think about pictures that are hard to, forge or fake, right? If you're with a whole family celebration in Christmas, then it's hard to stage that picture. Okay, so those are basically the documents that are needed. Generally speaking, the documents needed for a marriage case. If you were married before, you need to show that you have a divorce decree. Every case is different. Every case has a different fact pattern. So it's really recommended to go to the website, uscis.gov, and go look at on the form I-130 and check out the document list. It's really helpful. Okay, great. So moving on, I have 2 more questions that I want to talk to you about today. And if you have any more questions, you can write them in the comments, or if you're watching the replay of this, also feel free to write the question. Okay, I'm a U.S. citizen. My parents came to visit me, and now they want to stay permanently. Can I petition them here in the U.S.? This happened so much in the last 6 months because, and it's a great question. So a lot of parents came around the beginning of the year, on January, February, maybe December of last year, came to visit the family, came to visit their grandkids, and then COVID-19 happened, and it became impossible to go back. So some people decided to file to extend their status if they came in as a tourist, but a lot of other people decided to file for their green card and to file to adjust their status because they have kids that are U.S. citizens and they can petition them. So yes, as a U.S. citizen, you can petition for your parents if they came in with a visa and they decided at some point that they want to stay more, then you can absolutely petition them. You can petition them here in the U.S. They don't need to leave. They can do the whole process start to finish. Okay. Again, this is general information. This is just a generally speaking. Every case is a little different, but in the big picture, yes, your parents, even if they came in with a visa, they can, with a tourist visa, they can apply to adjust your status. Be careful about how quickly after they came in with a tourist visa, they apply to adjust their status. Okay, you don't want it to be too close because you might have issues of intent. Okay. And the last question for today, there's so many questions, that come up all the time, but I just picked the top 8 questions. Okay. I have a green card. Can I petition my kids that are living abroad now? Or do I need to wait to become a citizen, to be a citizen first? Okay. Really, really common question. Someone just got their green card and now they have children that are abroad and they want to petition their children. Do they petition them now or do they petition them when they become citizens? So my answer to this is this. This is my answer to this, right? It depends on how old your children are. It depends what the priority date is. There's a lot that goes into it. But right now, the priority date for minor children of green card holders is current. So if you have a child that's under 21 and unmarried, and they live abroad, you can file for them right away. There's no wait for a visa for that category. Okay. And then if your children are older than 21, or if they're married, then there is a wait, and the wait depends on what country you're from. So it really depends. What I recommend is, yes, you can file for them as a green card holder, and once you become a citizen, you can upgrade your petition. Okay, you can upgrade them to a different category if it makes a difference with the priority dates. And then how do you know the dates? How do you know when a visa is available? You would check at the Visa Bulletin. The Visa Bulletin is advertised every month on the Department of State website. Today, they actually advertised October 2020 today. So it's available on the Department of State website and also on USCIS. Well, USCIS takes a few days. I'm not sure if it's updated there yet. Okay, but definitely something that you can check. So if you have a green card, can I petition? I would petition. I wouldn't wait just to get your place in line. And then once you become a citizen, you can upgrade your petition. Okay, wonderful. Thank you so much. I just noticed that I did not put our phone number up. So I'm going to put our phone number if you want to contact us, if you have a specific question. That's our number. Oops, missing a little number here. That is our number. Feel free to call us, to text us if you have any questions about your immigration case. I really recommend talking to an attorney. It's worth having a consultation one-on-one because there's a lot of little questions that come up during an immigration case. Even if a case is what's called straightforward, a lot of people like to say that their case is really easy, really straightforward, they have no issues. Every case has issues. Every case has little things, and that's what we do every day. We help, people apply for green cards, and we help families come together, and we'd love to help you with your case. So feel free to reach out anytime. So that's all for today. Have a great week, and I'll be here next week, Thursday at 6:30 p.m. Pacific time. Bye, guys.